city after you lose your acceptance of responsibility, and 2 points for obstruction of justice. So you better know what's going on in that debriefing before you get there. So we're there in the debriefing, and like I said, it's 5 or 6 federal agents, the AUSA, my client and myself, and Diane. And then they started going into something that they didn't tell me about. And they wanted us to sit there and allow, and I knew my client was lying. I knew it was lying, just lying out. And I knew it. And so I stopped the debriefing. That AUSA got so upset, he slammed on the table. This is bullshit. We're going to have this debriefing and we're going to have it now. I said, no, you're not. And it's just that simple. I don't care how much you slam on the table. And I don't care how loud you roar your voice. This debriefing ends here and it ends now. And it's over with. And we were chest to chest, going at it. But I had no fear. Because like Windi said, he can't hit me. And if he did, he better hope like hell he can do something else. So, you know, after that, he filed a motion against me to have me recused. Because he said that I was acting under Chip Lewis's, because there was a co-defendant type deal going on. No, it wasn't that. It wasn't the fact that I represented someone that knew Chip Lewis's client. I represented my client. I don't care about what Chip Lewis' client has going on, and I don't. What I care about is this young man that's sitting in front of me, and you were going into an area I wasn't prepared for, and I was not going to let you do that. And I filed a 31-page response to his motion to recuse me. And by the time the judge heard it, the judge told him, I've stopped plenty debriefings in my day as a defense lawyer. She did what she was supposed to do. There's nothing wrong with that. So go tuck your head between your legs and go on, and she's standing on this case. But I was brave. I was not intimidated. Just because I was the only woman sitting there, because there were no other women in that room besides Diane and myself. But that did not intimidate me. So be brave. And you deal with federal agents by letting them know you are in control, because nothing is more important than your client's rights. Nothing. We have a constitution that we swore to protect. That ought to mean something to you. It ought to mean something to you because it means something to your client, it means something to your client's wife, children, and mother. It ought to mean something to you. I'll tell you another story. I know you all guys heard of the road rage case that I had, where the young lady ended up having to shoot the guy who ran up to her car and was beating on her car, what have you. I knew her father. And so maybe 20 minutes after that, he called and he said, hey, Letitia, my daughter just shot a guy. Get up here now, please. I rush up there, leave court, rush up there. And when I get there, I'm trying to let the police officers know that her family has hired a lawyer. I don't want her talking. Okay? I need to be able to talk to her before you talk to her, before she gives you a detailed event of what happened, because you're going to twist her words around like you always do. And so there I am. I need to talk with my client. I need to talk with my client. They would not let me talk with her. And so I'm, hey, Crystal, hey, I'm your lawyer. You know what they did? They went back and they said there's this belligerent woman who's boisterous, who's loud, and who's uncouth and unethical. Because I was out there trying to get word to my client. Be quiet. Like when they say, you have a right to remain silent until you receive counsel. And so that's the picture they painted for me. And so while we were out there that day, the pastor came over to me, you gotta be quiet. I said, no, you don't understand. I know these people. I know how HPD works. I know what's at stake. There's a dead man on the ground here. That's a murder case, sir. So it doesn't matter what I have to do. If I have to jump, if I have to scream, if I have to holler, I need to protect my client. Oh, don't worry about it. They're not going to indict her. It was self-defense, da-da-da-da-da. And I don't have to tell you she was indicted. I don't have to tell you that there's a murder case pending against this young girl who's never been in trouble a day in her life, but was sitting in her car and some crazed man, and the individual who was with the guy, his best friend, his exact words to the police officer that day was, if he was acting like that with me, I probably would have shot him too. But she's indicted now. But guess what? They will not be able to use that statement she made. And you know why? because they denied her right to counsel. Because everybody remembers me out there screaming, hollering, and jumping, let me talk to my client. And they wouldn't let me do it. So I protected her. I don't care how you view me. It's not about me. It's about my client. And so now, of course, the DA's office had to concede, we can't use this statement because you guys denied her right to counsel. So there are no lengths that we should go to as a woman. There's no place where your bravado should stop. You should do whatever it takes to make what you need to make happen in regards to your client's rights. And finally, how do we deal with witnesses on the stand? I think it's, one thing about being a woman, our bedside manner is always going to be better than yours. Because we have more patience. We have more nurturing, right? We have more love. We have more compassion. We're more emotional. Use that as a tool. Don't look at it as a detriment. Use it as a tool. So when you get that witness on the stand, who's a complaining witness for a sexual assault, you're able to identify with her in ways a man cannot because you are a woman. And you know you've been in that situation before, or almost been in that situation, or could at least appreciate that situation. So you're able to draw from areas where they cannot. Because you dated that guy before who took advantage of you, or at least tried to. At least once in your life, right? I mean, let's keep it real. And you said no, and he seemed not to understand that. But you also know how not to place yourself in situations as a woman. So you're able to cross-examine that sexual assault complainant a whole lot better than a man can. So you use all of your resources to deal with witnesses, to deal with judges, to deal with prosecutors, to deal with clients, to deal with federal agents, and to deal with police officers. Don't be afraid of all the accolades of being a woman. Just know what they are and use them. Diane, I'm speaking of Diane, she works for me, and she's my protege that I say that I'm going to train. And she came in the office when she first started working for me, and she started crying. I said, no, we don't do that in here. Not in here. You're a lawyer. You leave that emotional stuff out the door because you have to learn how to have tough skin. Because if everything bothers you, if everything hurts your feelings, this ain't the playground for you. Because folks are going to hurt your feelings. Judges, Judge Hitler being one, will hurt your feelings. Judge Strickland would hurt my feelings. In fact, he told me one time, you know what, you talk too much and don't know when to shut up. I said, well, since you don't like me, I file a motion to recuse. And he said, denied. But he didn't hurt my feelings. Just because he didn't like me, I don't care. I'm not here for popularity contests. I'm here to represent my client. And so those are some of the things that you can use as a woman, to empower yourself. So in the end, I hope that I've taught you or at least shared with you many different situations where being a woman can be beneficial to you. I have found that being a woman has not stopped me from being a great defense attorney. It has not stopped me from earning a very good living to take care of me and my children. It has not stopped me from protecting the Constitution. So I encourage you to fight. I encourage you to have bravado. I encourage you to be on time. I encourage you to be prepared. And I encourage you to set yourself apart from the next lawyer sitting next to you. By when you leave the courtroom, as my mentor told me, there should be blood, piss, sweat, and tears on the ceiling. And if that's not there, you haven't done your job.
Okay, next coming to the stage is Casie. Casie, I've been known for the longest, and I guess to go back to juvenile law at U of A when I was visiting. Casie is a phenomenal lawyer. I'm calling her Queen Murder Not Guilty because that's all that seems to be happening for her here lately. But she's amazing. She's amazing in trial, but she has this unique ability to connect with, it's not just connect. She has a unique ability to tell the story and empathize with the story of not only her clients, but she does it to a degree where she can take on exactly what the complaining witness experienced and relate to them in a way to get out what they were really thinking, especially when it is beneficial to her case. She makes the juries relate to her client's experience because she's able to empathize and tell the story like no other. I remember her first case, I got to see her get her verdict on. It was way back in the day, misdemeanor, she had red curly hair, and it was a prosecution case. And they came back, yes, they came back not guilty, and she's jumping all over the courtroom. And then I see her progress later on, and I see her give the most amazing closing argument on it's a tough sexual assault case. Her client was charged with mutilating his girlfriend, wife, I can't remember, because I guess they played the sex game where he took a lighter and he kind of would stroke it, and it burned her. So they charged him with mutilation, and let's be honest, that's something that makes everybody uncomfortable. Nobody wants to talk about sex. Nobody wants to bring it up. And when you heard the details, just like he burned her, that was wrong. But she gave this closing argument, and she did something I hadn't seen done before. She gave it in first person, from the victim's standpoint. And she addressed the sex issue at first. I think her words were, yes, this was a game. We played it. I'm grown. I can enjoy any kind of sex, and I like this, and this is what we do. And I watched the prosecutors squirm and refigure how they were going to go about handling this case. And I was surprised them by saying, and the victim will get on the stand and tell you that. And everybody was just like, ooh, interesting. She addressed it head on. But she's not just a phenomenal trial attorney because, hell, I've said in other closing arguments she's given and she's great at close. And she will bring you and the jury to tears and then go and sit right on a notepad, and I'm not sure what she's writing, but it's good. But she's also an attorney that will see a young woman in court, in a court which will remain nameless, that she doesn't know, and seeing the judge and the prosecutor take advantage of her. And I saw Casie march to the back. She has this girl, and I'm just like, what are you? So nosy, I'm gonna go and check it out. No, you're not gonna do any of those things. You're gonna get the offense report. We're gonna look over the offense report. Me and you're gonna work this together, but you gotta stand up and you gotta make the argument for your client. And she stuck through it. That's who Casie is. That's what she brings to the table. She doesn't just bring other members of the defense bar. She goes all in for her clients. And she definitely takes the approach, you will go through me to get to my client. And she's never been a pushover type chick. So, without anything further, Casie.
Thank you, T.I. I'm a little embarrassed. Thank you. That's wonderful to hear. That was the prostitution case was the first trial that I'd ever done. I have to tell you that standing here right now, I am overwhelmed with a sense of PTSD in this courtroom right now. You know, when Tiago had asked me to come and speak, I put together this presentation about presenting a criminal case and then identifying gender issues for your jury. And then when I walked in this door at about 10 minutes to 1 o'clock, I wasn't 15 minutes early. I was in this room for 10 weeks on that writ hearing for David Temple. And he sat at the end of this table in that yellow jumpsuit for 10 weeks. And to say that he was institutionalized is an understatement. I'd given him a pen and a piece of paper so that he could write me questions if he needed to ask anything. And he quite literally wouldn't reach for that pen unless he'd gotten permission from the bailiff. As heartbreaking as that is, what hurt more was the testimony that came out of that box, right there, that box, from members of the district attorney's office. I caught myself grabbing my jaw to close my mouth at some of the shit that I heard. You know, we see these emails go out about Brady issues, and we're getting Brady notice on this. This is not individual instances of Brady violations, folks. This is a systemic problem, and I mean from the top down. and the head of appellate can get on this stand and say that a baby prosecutor who has questions about whether or not a piece of evidence is Brady, the question they should be asking themselves is, would this undermine someone's confidence in the verdict? Well, we don't have a verdict yet, folks, because we're pre-trial. And so again, what question should a baby prosecutor ask themselves if they're staring at a piece of potential Brady evidence? Well, if it doesn't undermine confidence in the verdict, it's not Brady. That's from the head of the appellate section. And so, keep that in mind as we go through how I prepare my cases. Now, I've always been pretty thorough with using open records, but after having lived through those 10 weeks and watched what I believe was just a coordinated, concentrated effort to keep that man in prison, I've tweaked the way that I approach my cases now. Two people had asked me to give an update on that. We're still submitting findings of fact and conclusions of law. The state will get another 30 days to respond. And then very shortly thereafter, I hope to get David out. So that's the update. Preparing a case for trial, all right? Preparing, presentation, and then these gender issues. I talked to a couple of lawyers right after TI that asked me to come and do this talk about just their opinion about whether or not they should have a woman as part of trial counsel. And without fail, and I'll tell you, it was Don Flanner, it was Jerry Goldstein, it was John Hunter, and Stan Schneider. And without fail, they were of the opinion that yes, we do want to have a woman as part of the trial team. Their reasons were many. But much for the same reason, I'll never understand what it's like to be a black woman, right? I'm never going to see the same set of stimulus the way any one of you will. And the white guys in here will never see it the way that this white chick sees it. And so if you're going to prepare your case and do it in a way that you're going to be able to effectively present it to hopefully a diverse jury, you need to have some diversity on that team starting off. And I think that, you know, especially with the sex cases, fellas, shit does not happen that way, okay? It just doesn't. I was in San Antonio just last week consulting on a sex assault case. And it's, you know, 19-year-old rich boy frat guy. He says it's consent, she says it's rape. So I'm interviewing him, and, you know, he's got me so far. She shows up, you know, wants to have sex. It's like 4 in the morning. She's been out drinking. So we go upstairs. We do it. She wants me to spank her. She wants me to, you know, and I quote, fuck her in the ass. And so I do it like it was some big, you know, imposition on him to do all of this. Yeah, he did her a favor. So when he was done doing these favors for her, he goes into the other room, not downstairs yet, into the other room to finish playing World of Warcraft with this video game thing. And then she, like about a half hour later, she comes in and she begins to give him oral sex. But he's distracting her. I mean, she's distracting him from his video game. And he's getting pissed off about it. And so when he pushes her, he said she rocked back on her knees, then goes forward and gags herself and barfed on him because she's giving him oral sex under the desk. I'm lost at this point. Like, yeah, you got me. I literally felt myself check out while the 3 male lawyers in the room were listening and looking at me, waiting on my reaction, because they believe him. Yeah, I'm gone at this point because I don't know a woman that goes ass to mouth, willfully. I just don't. Never heard it. No. Now, mind you, she was saying that he forced her to do that. That starts to ring true. But I mean, am I missing something? I know people exist in fiction, but so again, the 3 guys in the room never would have, and I'm sorry? No. prevalent as, at least in my 42 years of being on the planet and the wide group of female friends that I've got. So things like that, when you're prepping the case, it's nice to have a second perspective. And whether that's race, whether that's sex, whether that's religion, whether that's nationality, you have to look at the case from all angles and find whatever reason. I mean, I look around this room right now, and this is a pretty diverse group. If only we could get veneers that look like this, that would be fantastic. But in prepping the case, I think you do a disservice to your clients if you're not mindful of that. If you're not keeping your antenna up for experiences that you're just ignorant of by virtue of your skin or your sex, etc. So I wanted to share that with you because I'm obviously prejudiced because I like to try cases and I love trying cases with all those guys, but all four of them shared that with me, that they specifically think it's a good idea to have a woman as co-counsel. In my personal experience, I can tell you that if you've got an asshole cop, they're so used to dealing with female prosecutors that they expect me to act like a female prosecutor, and I don't do that. And so they lose credibility by the bucket load when they start beating up on them and being obstreperous and not answering and not responsive, and I let them. Because the only people that do that are liars. And the jury sees it. I mean, we're in South Texas. Hello, I'm a girl. You can't beat up on me, big bad cop. You can't. And they get angry about it. They'll start shuffling in their chairs and leaning forward. Stan Schneider can't do that. Stan Schneider can stand, or any other guy can stand toe-to-toe and fight with him, right? And so there's some strategic reasons, I think, when you select the sex of the lawyer that's going to be questioning the witness. I can tell you with my defendants, with my clients, if they can't get past my cross-examination, or if because again, most of the prosecutors I deal with are female, and my Mexican national or South American or Central American older fellows do not do well with women in authority. They just do not do it. So if they can't get past me, then I can't let them, I can't let Marie Prim go at them. That's gonna go real bad real fast. It's just not gonna work. So my pitch about dual sex trial teams is just that. You've got a lot more options. You can tag team. There's a lot of strategically beneficial reasons why you should consider either bringing in a man or bringing in a woman. So, any questions or comments about that? Good. I want to specifically talk to you about discovery, and I'm mindful of the time, so Vivian, I want you to throw a pin at me if I go past 2:30, okay?
You can have all my time.
Yeah. Very quickly, one of the things that happened in the Temple case that would be very difficult to do now because of the way that the offense reporting systems work is Kelly Stiegler closed the file to Dick Guerin, okay? And I'm talking 1,400 pages of offense reports, folks, like this, right? Single-space typed offense reports. And what she would do is she would have a member of the defense team come in and she would read to them select portions of this offense report. And it was only those portions that implicated David Temple. Witness statements, identity of witnesses, alternate suspects, locations of shotguns. Belinda Temple was murdered with a 12-gauge double-aught shotgun with a reloaded shotgun shell. Law enforcement found a 12-gauge shotgun with a spent, reloaded double-aught buckshot shell in it. Kelly never disclosed to the defense where that came from. Actually, that's in this statement. Kelly affirmatively misrepresented not only to the defense, but to the judge on the record where that gun had come from. So, when you start dealing with evidence and chains of evidence, do not just file a Brady motion expecting this officer of the court to be honest, because they lie, and they're comfortable with it, and good at it, okay? Start subpoenaing the law enforcement agencies. custody records, okay? It's going to be submitted to the Pasadena lab for either presence of blood or presence of some biological material. It'll be submitted to the evidence room, I forget what that's called. Yeah, it's the evidence room. They'll have their own chain of custody records. Subpoena those documents. Because if you just rely on what this officer of the court is saying, it's a crapshoot. You know, I see Craig Still over here out of the corner of my eye, and I am reminded that they don't all suck, okay? They don't. There are many prosecutors that I'm friends with now that are still prosecuting, that I trust. You know, I still do my due diligence. And then there's another lot of them, not as far as I can throw their asses, okay? And so, back to whether or not you can rely on what they say and what you subpoena, consider asking for the same document from those alternate agencies, okay? That combats the lies that we get from this side of the room, but it also combats some of the lies you get from law enforcement. Because remember, the prosecutors have only got what the cops have given them, right? They're the ones that put together the offense reports. They're the ones that then, or at least they're in this sort of transitional system between the old offense, the online offense reporting system, and the CAD system that we've got now. But generally speaking, they were the ones, the cops are the ones that write up the offense reports. They submit that to the district attorney. And so, to some extent, your DAs are relying on what they've already been provided from the sheriff's department. Okay, well, you start looking at the Casie Whitley, prosecutor still has an affirmative duty to go and look for the stuff you ask for specifically. Cut them out. Go get it yourself. File an open records request with the sheriff's department, with HPD, DPS, every imaginable source. And then when you get all those things together and you start comparing timelines, if there's a hole to be found, it's going to jump out at you. Speaking of those offense reporting systems, have you ever wondered what that number was, that CAD number was in the top left-hand corner of your offense reports? It's a computer-aided dispatch number that's auto-generated. How many people in this room have gotten an offense report and you've been like, this has been tweaked, this is not right? See your hands. Yeah, it happens too frequently for it not to be a thing. That CAD number, if an officer witnesses a crime, right, they see it happen,